appeal, British American Tobacco Denmark and Kazemier Transport.
Lord Mance will explain the judgment of the court.
Cigarettes attract smokers, smugglers and thieves. This case is about cigarettes lost by theft during international carriage by road, in one case by an alleged hijack of a whole container in Belgium, and in the other case by theft from a container parked overnight near Copenhagen. The question is whether the consignors, who are two companies in the British American Tobacco Group, BAT, can sue in England not only the main contractors, XL, but also the subcontractors, Essers and Kazemier, who were in possession of the containers at the times of the losses alleged. Since this was international carriage by road, the answer depends upon the Convention on the Contract for the International Carriage of Goods by Road, 1956, CMR, which was given the force of law in the United Kingdom by the Carriage of Goods by Road Act 1965. It is common ground on this appeal that Essers and Kazemier were successive carriers in terms of the Convention, becoming therefore parties to the main CMR contract on that basis, even though the main contractors never performed any part of the international carriage. Article 34 of CMR provides that where a contract of carriage is performed by successive carriers, each is liable, in effect in full, for the performance of the whole operation. Article 31 permits a claimant to bring an action in any court or tribunal of a contracting country designated by agreement between the parties, and in addition, in the courts or tribunals of a country within whose territory either the defendant is ordinarily resident or has his principal place of business or the branch or agency through which the contract of carriage was made, or B, within which is the place where the goods were taken over by the carrier or the place designated for delivery, and it permits no other courts or tribunals. Article 36 provides that claims may be brought against the first and last carriers and the carrier in possession of the goods when the loss, damage or delay occurred, and ends by saying that an action may be brought at the same time against several of these carriers. One question on this appeal is whether this last phrase applies subject to Article 31 or constitutes an additional head of jurisdiction over a foreign defendant. Mr. Justice Cook set aside the service of claims forms on Essers and Kazemier. The Court of Appeal reversed him and upheld the service. Essers and Kazemier now appeal to the Supreme Court. The Supreme Court allows the appeals and restores Mr. Justice Cook's order. Lord Mance writes the lead judgment with which Lord Newburgh and Lord Reid agree. Lord Sumption and Lord Clark write concurring judgments. The reasons for the judgment are these. Article 31 applies as stated to disputes where a successive carrier is involved and specifies certain heads of jurisdiction. The third head, where the goods were taken over or delivered, can be ruled out at once since the goods were not taken over or delivered in England. As to the first head, that is, courts of a country agreed by the parties of having jurisdiction, the question is whether Essers and Kazemier became party not merely to the main contract, but also to the English jurisdiction clause in the main contract between the consignors, BAT, and the main contractors, XL. Article 34 provides that a successive carrier becomes party to the main contract under the terms of the consignment note. Here, no reference was made to any jurisdiction clause in either consignment note. Under Article 34, therefore, and as a matter of general principle, Essers and Kazemier are not bound by a choice of court clause not evidenced by the consignment note, and so of which they had no express notice. As to the second head, that is, courts of a country where the defendant is ordinarily resident or has his principal place of business or the branch through which the contract was made, Essers and Kazemier are not ordinarily resident in England and do not have their principal place of business here. Further, they are liable as successive carriers not because anyone made a contract with them through any branch or agency, but simply because CMR makes them a party by statute in consequence of their accepting the goods and the consignment note. So the second head does not assist BAT either. This leads back to the question whether the last phrase in Article 36 operates as an additional head of jurisdiction to enable BAT to join Essers and Kazemier to the proceedings in England against the main contractors XL. The Supreme Court holds that it does not. The last phrase merely affirms the principle that the first, last, and performing carriers have joint and several liability in full rather than alternative or partial liability. The final issue is whether Article 6.1 of Council Regulation EC number 44/2001, that is the Brussels regulation, itself provides an additional basis for joining Essers and Kazemier or otherwise aids or affects the interpretation of CMR. CMR was concluded before the United Kingdom acceded to the European treaties, and Article 351 of the Treaty on the Functioning of the European Union provides that rights and obligations arising from treaties concluded between a member state before its accession to the EU and one or more third countries shall not be affected by the provisions of the European treaties. CMR is such an agreement or treaty with third countries. It represents a balanced regime adopted across 55 states, only half of which are in the EU. Its jurisdictional provisions do not impinge on any principle of EU law, which the Court of Justice has in other cases held should prevail. Accordingly, there is no basis for refusing to give effect to the provisions of CMR. Lord Clark and Lord Sumption consider that the commercial logic of Articles 34 and 36 point towards the recognition of a jurisdiction to receive claims against all three carriers in one set of proceedings, but agree with Lord Mance that the judgment of the CMR clearly provides otherwise.
Court is now adjourned.